If you've entered the United States without inspection or illegally through the border, then the absolute most important thing for you to understand in immigration law is the relationship between 601A waivers and parole programs. So a 601A waiver is called an unlawful presence waiver. And I think the easiest way for me to explain this is to give you an example. So let's say you entered through the border without inspection 15 years ago. And then after some time, you married a US citizen. And now you want to try to become a permanent resident based on a family petition to your US citizen spouse. Well, the way it would traditionally work is your spouse would file a family petition for you. After that family petition gets approved, you need to apply for an unlawful presence waiver. And the reason why you need to apply for an unlawful presence waiver is you need to go back to your home country to attend a consular interview at the US Embassy or consulate, and then you need to legally re-enter the US with an immigrant visa, which will allow you to become a permanent resident as soon as you re-enter the United States. But the problem is, as soon as you've been in the United States unlawfully for more than 365 days, then when you leave, you will trigger a 10-year bar. So basically, you'll go through the process, you'll schedule your consular interview, you'll leave the United States, triggering a 10-year bar to attend your interview, and then when you get to the consulate, they'll say, "So sorry, you're inadmissible for 10 years, wait here," or you can apply for a waiver while you're outside of the United States and wait 6 or more months for them to make a decision on it. Not an ideal situation. So the unlawful presence waiver, the 601A waiver, allows you to apply to waive that unlawful presence before you leave the United States, so that if it gets approved, now we can schedule your consular interview, you can leave, and they won't consider your unlawful presence when they're making a decision on your immigrant visa. Something that many people are confused about is how they can qualify for the 601A waiver. There is a very specific way that you can qualify, and that is by showing that you have a permanent resident or US citizen, spouse, or parent. Notice that I didn't say child. If you have a child over 21 and they're petitioning for you, the petition will get approved. But after the petition gets approved, you won't qualify for the unlawful presence waiver unless you have a spouse or a parent who's at least a permanent resident or a US citizen. And then you would need to show that this qualifying relative, this spouse or parent, will suffer hardship if you're unable to remain in the United States. Some clear examples of hardship are that your US citizen spouse has some sort of disability, or even, something like back pain, and we can get documentation that they depend on you for their day-to-day functioning. Other evidence can include mental hardships like depression or anxiety that's very well documented. PTSD or past trauma is also a great example of emotional hardship. And the weakest type of evidence is financial hardship. Financial hardship could mean that your US citizen spouse is depending on you, the immigrant spouse, for financial dependence. Financial hardship by itself is almost never enough to qualify for the 601A waiver. So the best way to think about this is that your qualifying relative, spouse, or parent needs to basically suffer more than a normal spouse or parent who's losing their immigrant spouse or immigrant child to the immigration process. If we can show that they will suffer more than a normal person would through family separation related issues like loss of companionship, loss of a child to the immigration process, then we might be able to qualify for the 601A unlawful presence waiver. And by the way, in 2024, at the time I'm filming this, the 601A waiver has an average processing time of 46 months. So you're easily adding up to 4 years to the immigration process. on top of how long it takes for immigration to process your I-130 family petition. And then after the waiver is approved, we still have to do consular processing with the National Visa Center, schedule a consular interview, which can altogether add another year to that process. So start to finish, we might be looking at a 6-year immigration process. Now let's talk about parole and the role it has and the relationship it has to the 601A waiver. Parole is a way to fix an illegal entry. Biden just announced a new parole program for spouses of US citizens, and this can help thousands of people avoid having to leave the United States to go to a consular interview. Because remember, if we can fix your unlawful entry, then you don't leave the US. You don't trigger unlawful presence bar, so we don't need a 601A waiver. If we can fix your illegal entry through parole, we can apply for adjustment of status inside the United States. You don't need to leave to go to a consular interview. Even though Biden just announced this program for spouses of US citizens, it's not the only way you can be granted parole. I've made several videos on this topic, so I encourage you to check them out. And by the way, if you're new to my channel, I put out videos on these topics on a weekly basis. You should check out some of the ones I've made on ways to qualify for parole. And if you ever have any specific questions on how to do any of these immigration processes, or you need a lawyer to walk you through it and represent you and prepare your whole case from start to finish, please feel free to reach out to me. You can schedule a consultation and I'll help you in every way that I can. There are several other ways that you can qualify for parole. One of them is if you have a family member in the military. If you have a spouse or child that's in the US Armed Forces, you might qualify for something called military parole in place. So the way this would work is, let's say you've been here without authorization, without status for many years, and you entered illegally, and you have a child who's 20 years old and in the Army. That child can help you apply for military parole in place, and that will allow you to fix your illegal entry. And the moment that child reaches the age of 21, they could file a family petition for you, and you might qualify to apply for permanent residence through the adjustment of status process while inside the United States. You won't have to leave. You won't need a spouse or a parent to qualify for an unlawful presence waiver or 601A waiver. Another way that you can qualify is if you've ever been granted temporary protected status or DACA, TPS or DACA. These are like provisional immigration statuses, and they allow you to apply for something called advanced parole, which is basically a one-time permission to leave the United States for some sort of urgent or humanitarian reason, such as visiting an ill or elderly family member. You can even go to visit a grave of someone who's died, and then you re-enter the US with parole, and now you've fixed your illegal entry. And if you have a qualifying family member who can petition for you, like a US citizen spouse or a US citizen child who's over the age of 21, you can be eligible to apply for adjustment of status inside the United States. Alright guys, that brings us to the end of today's video. If you have any questions, put them in the comments below. I'll try my best to answer them within a week of each video posting. After that, you'll have to post it on my most recent video for me to respond. If you're new to my channel, be sure to subscribe. If you need immigration help, reach out to me. I'd be happy to assist. And I'll see you guys next week for another video.